What do they
So
do?
we
What
need-
do they do with that though? Because some of them go back to their car, type some bollocks in their computer, and then come back to you and say, okay, we'll see you later.
Sorry, see you what?
So, take care, see you later, here's your ID back, see you later. That's it. So they just check something on their system, obviously, to see if you've
Okay,
previously
so long as
offended.
you can, so long as you don't give them reason to believe that you're lying to them, okay, the interaction stops once they've got your name and address. Same thing with the judge. So whether they say, JP, Your Honour, Joe Blogs, or JP, Your Honour, Blogs, it doesn't matter. What's important is that if they act unlawfully, you know where you can serve the claim against them. Okay? So I don't need their first name, I don't need their house address, because I know what time, which court, and there'll be a record of JP, Your Honour, XYZ. Okay? So you don't need first name, surname, and house address. You only need to be able to serve them your claim. So long as you've got sufficient information to be able to serve them your claim, that suffices. Okay? So that's the substance as to why they will arrest you if you don't give them your name and address.
I've got evidence there of that one. I've got a claim. I've just called the company the Archco, and they responded saying there's no such company, but the correct company is the Arch Company Property Company Limited, some bollocks like that.
It doesn't matter.
But
By
they're still
admitting that,
They're still defending that plus the name that I put.
yeah, okay? What they've done is, they've
Accepting
acknowledged they've been
That's
served, and by that, correcting and putting their correct name,
Yep.
they've now confirmed service
Correct.
and of substance.
Mhm.
Okay? So whether it's Mr. or capital letters or small letters or all caps or mixture, irrelevant, because equity prevails, substance over form. So that happened there, but now it's much easier, because at that time we were familiar with Regina versus Felixstowe, we weren't familiar with this little diamond. So what we do now, and we did this with Paul, okay, we just pulled this up and said, are you familiar with the Equal Treatment Bench Book? And with their egos, they say, absolutely, guaranteed, because they can't say no. Even if they don't know what it is, you saying Equal Treatment Bench Book. I'm on the bench, and I've got to treat, shit, maybe this applies, of course I know what this is. Okay, now you can use this tool. They will, so far, they've never denied, and they've never gone against what we've quoted out of this. And all we're doing is, basically going through, well, in there, what's your name? What's the legal officer's name? Okay, what the hell's going on here? What's everybody's roles, duties, responsibilities? So an incredibly powerful tool, okay? And I'm not a fan of, I'm not worried about the judicial oath, okay? It sort of pisses them off, is the general reaction when people ask the question, are you acting under your oath? Okay? Because I tackle it from a different viewpoint. You sitting there as a judge, you, through your actions, are there under your judicial oath. And should you not comply with your judicial oath, I'm creating a record and I'm going to hold you to account. So I don't need to know if you're acting, I don't need you to say yes or no or anything like that. But I avoid the, well, of course I am, or no I'm not, or I avoid that confrontation totally. But everybody deals with it differently, no way is right, okay? So, now, let's just go through the way that this should happen, and this is basically out of the Equal Treatment Bench Book. Okay, can you confirm your name, please?
Roman Redford,
And your address, please?
10 Sheep Street,
Right, and your date of birth?
30th of the 10th, 52.
Right, welcome, Rome. Okay, now, I'm Judge blah blah, and the legal officer is blah blah blah, and the prosecutor is blah blah blah. What's going to happen today is, all right, they've claimed that you've been a naughty boy, and we'll go through and explain what all those charges mean. Now, my role as the judge is that I'm here to resolve the dispute between you two. First job that I've got to do is to determine joinder. What is the relationship between you and the claimant, so that we can establish your respective duties, rights and obligations to one another. Do you understand?
That takes the fear out of everything now.
Do you understand?
Yeah.
Yeah. Okay, so if at any point you don't actually understand what's going on, feel free to ask. If they use any language that you don't understand, okay, and they're under obligation, if they use a specific term which is, you know, with evidence or anything to do with proceedings, they are under obligation to explain to you what they mean. If at any point you feel that you don't understand what's going on, just interrupt and ask. Okay? Right, now, his obligation as a prosecutor is to provide their claim. And that means they need to provide all evidence in favour and in dissent of their claim, because they are officers of the court, as is the legal advisor. You're a lay person, and they are here to assist you, because their obligations are to the rule of law, to the court, and to me, the court. They cannot knowingly or recklessly misguide me. They cannot hide any evidence, and if you feel there's anything that you need that they've not disclosed, simply ask. Okay? So both of them are here to assist you, should you need it. Happy? You understand what our roles are? Okay, next the procedure of what should happen is, they're the claimant. They're under the obligation, because this is a criminal matter, to provide evidence which must sway me and my two fellow magistrates beyond reasonable doubt, okay, that it's true. They present their evidence, they present their witnesses, then you get the opportunity to cross-examine the witnesses. Once you've cross-examined the witnesses, they get a chance, if there's anything you brought up which they feel needs more clarification, they will get another opportunity to re-cross-examine. However, you, the defendant, and therefore, you will always have the final say. So should they re-examine, it'll revert to you if you want to ask any further questions. Okay? Then what happens is, they've presented their evidence, now it's time for you to present your defense. So, you'll present your witnesses, they get the opportunity to cross-examine. Then, should you wish to re-cross-examine, you can re-cross-examine anything. Should they wish to re-cross-examine anything further that comes out, they have the right. And you are the defendant, therefore you always have the final say. So until you're happy that you are satisfied, you've presented the best case before me, I will always ask you before I step further. Happy with that? Right, then based upon the evidence that I've seen and been presented to me, I will consider it with my fellow magistrates as to whether we find you guilty or not guilty of the fact. Any questions? No. Okay, cool. Yeah, that's how a magistrate's court should be run. End of.
But I would being the claimant, would say, you are acting at my disadvantage. You are prejudiced with the defendant.
Oh, am I really?
Yeah.
Are you not familiar with your obligations under the Legal Services Act 2007? I suggest you go and bloody read them. Okay? That is how it's meant to be. Okay? When you get to the higher courts, basically that is what happens. The judge will do exactly that sort of thing. It happens in the employment tribunal. Why doesn't it happen in the magistrates' court? Because nobody's got a bloody idea what goes on in there. And all we need is to pull up that. Okay? If they don't explain anything that I've just explained to you, you pull up this and say, "Oi mate, you've not told me what your role is." It's not good enough only having your name. You've got to explain what you're here to do. What is your duties, rights and obligations? Okay? So that there is what's meant to happen, and here's your tool that allows that to happen.
Is that for important tribunals or just magistrates?
No, it's the same for everything. Okay? What I've described is the way it should happen.
Yeah.
Why? Because it's about the law. Okay? The law is foundational. Legal officers' obligations are to the court. I must be with all the knowledge in order to make the best decision that I can. Okay? So, that's what's meant to happen. Many of you have been into court, and that certainly don't happen. That's why we're going to start evidencing this stuff. Okay? So basically, then they should present their case and say, who's the harmed party? Why? Because in order to sentence, harm must be shown. And then you just put down the summary of the claimed harm and or of the charges that they've put it down. Okay? So then the next thing is, so this is what the clerk will read out, or the legal advisor will read out after the introductions and, you know, order of ceremonies and what's going on and who's who. Rowan, how do you plead? Hmm?
So, you know where it says who is the harmed party,
Yeah,
and then the summary of the claimed harm.
yeah.
If you then question if it's a genuine harm at this stage,
That there, okay, is what the clerk will say, okay, you here under the claim of council tax regulations, blah, 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 and the claimant believes that you've not paid and you liable. So, who's the claimed harmed party? The council is claiming to be the harmed party. The summary of the claim is in accordance with Admin and Enforcement Regulations 92 that you've not paid their demand. Or a speeding ticket. Okay? So the claim is the harmed party, it can be the legal fiction. Remember, this is the claim. Okay? So when you go in, they will read you a summary of the charges against you, and this here is where you fill in those details. So it's a summary, and on the court's memorandum of entry, that's what's written in the court's memorandum of entry in the magistrate's court. Okay? We're not, oh sorry, the other thing with it is, sorry, don't interrupt unless it's really something urgent. Allow him to speak, and when they finish speaking, allow, you know, then come back. Now, with that there, one thing is, we need to object if they speak too fast because we write slowly. Can you just slow down a minute? Okay, I'm just writing down this claim. Okay? And why do we want to do that? Because we want to try and deal with things on a point-by-point basis. Every single claim they make, we need a rebut. Okay, so that's what we're trying to do.
So you're
We
suggesting
trying to-
that somebody's sitting in the witness box?
Sorry?
So you're suggesting that whoever's sitting in the public gallery being a witness...
No, the
actually
public
sees
gallery
that
can't
as-
intervene, no. This is up to the person who's...
Well, so who's going to ask them to slow down so that the people in the public gallery have got more time to write?
Well, the important thing is, mainly, the person who's got makepiece in the public gallery is slowing it down to ensure that they've got enough time. Okay? But, yeah, it's a problem. Yeah, Nick?
same question.
Oh, okay. So, if you want a good record, it's up to you to ensure you make it possible for a good record. So, basically, the next thing then is, once the legal officer's given the summary of the claim, they'll ask you, how do you plead? Okay?
Mark,
So-
just 1 second.
Yeah?
Sorry, would be good advice then to,
With the...
if you're doing this role of auditing the court,
Yeah?
it'd be good advice to make sure the defendant knows, to make sure that they speak slow enough so that the auditor can write it down.
Yeah,
Make sure the defendant knows that.
yeah, if possible, okay. The idea with the structure that we're trying to put in with the voluntary association is, if I'm in court on this day in this area, I put it on my local group, that goes out to a bigger area and volunteers just appear. If I see somebody with an orange court auditor vest, I know there's somebody there to help me who's going to write down.
Right.
And therefore, I'm going to, and I don't have to know them.
No.
I might not, well, if I don't know them, it's better. But basically the idea is somehow we can identify so that you put out the cry for help, you can see people are here to help you, and therefore now it's your obligation to make sure that you give them the best opportunity to be able to help you. Okay. So how do you plead? Now I've said about the charges, okay. You want to argue points of law. Do they have jurisdiction? I.e., does the government through its Act of Parliament have authority to enforce their belief upon me? Okay? And so with a plea, really my suggestion, if you want to argue points of law, go in. There's no, they've not shown any evidence of harm or intended harm, therefore I can't enter a plea as there's no case to answer. What you're doing there is forcing them, the court, to not presume that legislation is law. Alright? Then what we're doing is we're putting in the applications for power of attorney so that we can try at least to get the right that not only are you a Mackenzie friend to nudge. Now there's a real problem with Mackenzie friends nudging, because you've got one person there with a train of thought and you've got another person here. Okay? So unless you're both on the same page, a Mackenzie friend actually can be useful or totally useless and really intervene and interfere. But what we're doing with the power of attorney is saying, if I need him to talk on my behalf, okay, here I'm asking the court, I've authorized them to talk on my behalf. Okay? So it's a direct challenge on the bar monopoly and their little control over that. And we've had about a 50% success rate with the Mackenzie friend. They've always said a Mackenzie friend, so they've not addressed the direct issue of representation. And half of the time, the Mackenzie friend has had the right of audience granted by the court. And twice have had the, and it's not only me, this is also with other people. I've been twice granted the right of audience even to cross-examine the prosecution witnesses. So we're starting to make a bit of headway with this stuff. If it's denied, why? You write down why. Because every single decision they need to explain. They can't just simply say no. If they're saying no, you say, in accordance with section 66 of the Magistrates Court Act, I require your reasoned decision. Please explain how you got to that decision. So with this is basically, in essence, yes, no. Was that request granted or denied? If not, why not? Was the next one granted or denied? If not, why not? If you've got not enough space, take that point number, continue, write the point number and continue writing on the back of the page. Next thing that we're doing is the recording. You're going to make an application to record. You're going to ask the guy about recording. So everyone has the right to self-defense, blah, 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 blah. This is your script, okay? And if you were granted it, you circle granted it. If you were denied it, why have you denied it to me? What are your reasonable grounds to deny me my right of self-defense? And then the next page is, we've been through the formalities. Now we're proceeding to the first stage, which is called pre-trial. Has everybody got what they need from the other party? So, the first thing needs to be the respective duties, rights and obligations, i.e. what is the lawful basis of the claim? So has the claimant stated the lawful basis, yes or no? If they've stated a legal basis, the answer is no. So if they start quoting legislation, they have not stated the lawful excuse to breach your peace. And have they given you the opportunity to rebut what they've said? Have they been given the opportunity to counter-rebut? And have you been given the final opportunity? Okay? Now, with this, the idea is, if they are claiming legislation, whatever it is, you're in breach of the Fraud Act, Section 2, you write breach of Fraud Act, Section 2. Breach of blah-de-blah, breach of blah-de-blah, breach of blah-de-blah. Okay? Now, you need to identify in each of those claims that they made, each point that they made, have they identified that the actual harm was done, was intended or was reasonably foreseeable to have been done. If you were at any point denied that right, why were you denied that right? Then, so this here is to first establish, is there a case to answer or not? That's what you're trying to force. What are the parties' respective duties, rights and obligations? If they railroad that, you want a record that you've been denied due process. The next thing then is disclosure. Has each party got what they want? List anything that is wanted by which party. And then, if they were denied it, why were they denied it? And then what should happen is the court should make an order saying, right, we need this disclosed by then, we need that disclosed by then, okay? And you need to confirm to the court that it's been done so that we can ensure it's trial ready. Once that's been done, it will proceed to trial. Okay? So, if they haven't followed the disclosure procedure, why? Then the next part then is for the trial itself. The claimant needs to present their evidence. You write down each claim that they make. Now, based upon the claim and what you've witnessed, do you believe that? Yes or no? Beyond a reasonable doubt, or on the balance of probability, or don't you believe it at all? Okay? So if they make 10 claims of pieces of evidence, you list each of those claims. And each one of those, you ask yourself, do I believe it, yes or no? To balance of probabilities, or to beyond reasonable doubt. Then, with the cross-examination, you make your determination. Once the evidence has been presented, you put in your judgment of each point on a point-by-point basis. Then the defendant's evidence, the same thing. Whatever they're saying, whatever the cross-examination is, then against each item, point by point, on the balance of probabilities, do you believe it? Do you believe it on beyond reasonable doubt? Because what you've got then with that is, if it's a criminal matter, and you've got a few things which you're not convinced beyond a reasonable doubt, or one thing that you're not beyond reasonable doubt convinced of what evidence you saw, that means it must be a not guilty verdict. Simple as that. Okay? And then the next page is basically, what is the judge or the jury's decision? What is their description of the harmed party? And what is their description of the state of mind? And what is their reasoning as to how they reached those conclusions? Then, the next thing is the Sentencing Act 2020, because based upon the harm caused, the facts, and the state of the mind, the sentencing needs to reflect that. So once that is over, the court must address the issue of costs. Did either party follow pre-action protocol? Didn't they? Was the cost evidence cross-examined? And who was awarded costs or who wasn't awarded costs? If any step is denied, why and what was the cost award? Okay? Now what happens normally in civil matters with costs, with criminal matters with costs, is they will award costs against the loser, but because we don't know that we can challenge these things, we don't challenge it. Okay? So if we say, look, I tried to resolve this in private, but they were, obfuscating and this, that and the other, and here's my evidence to show that they're the ones that created all of their own costs, you can't put costs on against me. So if you do not challenge, if you do not ask, you will not get. Simple as.
If you don't enter a plea,
Yeah?
and they can still continue forward. And
They can't continue forward. Okay? If they continue forward, by
Then in
them
order to find
entering
you-
a plea,
That's what I'm saying, but in order to find you guilty, you have to enter the plea, haven't you? So
no, what you've done is, by not entering a plea, you need to explain why you can't enter a plea. Because they've sent me this evidence pack. I only got it 5 days ago, it took them 3 months. So I can't enter a plea because I've not had an opportunity to evaluate the evidence. It took them 5 months, I need 15 months. Please adjourn the court for 15 months and then I'll come back and see whether I can or can't enter a plea, depending on what is in the evidence. I don't know what's in there. I'm not a legal professional. Once you've gone through the evidence, if there's no evidence of harm, you say they failed to show any harm. Therefore, there's no cause of action. Okay? And what you're doing is forcing them to discuss is legislation is law. Okay? How am I bound to their claim? Is there joinder? Okay?
and if they just enter a plea and carry on regardless, that's when we use it.
If they do not follow the due process, okay, you yourself, when you are going in there, you will be filling this in yourself as a claimant, as a defendant. Okay, you'll be creating your record. Okay, and this is one good way of ensuring there's sufficient time for anybody else to record. Because basically, if the claimant starts off, blah, 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 hang on, can you just slow down a bit? I can't write so fast. Okay? Sorry, you said this, and what was your next point? Okay? Blah, blah, blah. Slow down. Okay? You have every right to do that. Why? Because you need to understand.
And if they start saying, we can't wait for you, that would be affecting
Sorry,
your...
are you denying me my right to defend myself? Because that's a contempt of court. Okay? So anywhere where they deny you a right, you simply stop. Are you denying me the right? I object. You're denying me the right to defend myself, and that is a contempt of court. Now, if the prosecution does this 3 times, you turn around to the court and say, this is the 3rd time that they've done this, okay? Can you please hold them in contempt of court and deal with these people and hold them to account to their obligations to the rule of law and to the court? Okay? So we start turning around by taking control. Is this complicated? I think it's pretty simple.
Once you know it.
Once you know it, yeah.
Yeah,
Once
and so
you
the
know it.
idea is, with this should bring you in with at least an idea of what to expect. How should it operate? How do you start to create your record? How do you start to empower yourself to get them to do their jobs? If they see a dozen people walking in with sheets and court auditor stuff on this,
Yeah.
they see you sitting down, they say, oh, hang on, slow down. Oh, hang on, what's his role? Who's that person? Okay? Then they will change their behavior, even if you're on your own. Okay? So that's the whole idea, is to force them to do the right thing, give them the opportunity. And this here really is the summary, and all the substance, the meat behind it is that. This is the skeleton, okay? So, that's about it. Anybody got any questions, or anything they want to ask, or suggestions? Can I please ask, if anybody's, if you're going through the manual, if you find anything wrong in there, please, on all of the course pages, it's all broken down into segments. If you find something wrong in there, a link doesn't work, it's bullshit, whatever, everything's open for comments. We need your feedback. Why? Because together we will find the solution. This is only the start. If we can find better ways to simplify this stuff so that we can get this across for others to use, okay, that's what it's about. Finding the simplest way for something that works for everybody, not something that just works for me because of my character or my knowledge. We need tools which work for everybody. That's what I'm trying to create with Peacekeepers, and what I'm doing there. Something that everybody can use and everybody can benefit from. Okay?
Do you know on there, there's the website, you've got loads of links on there.
Yeah.
I mean, do we need to be going through those links?
No, you don't. You need to know where to find the information if you need it. That's the idea behind it. There are going to be 1 or 2 rowings. We're going to check every great link. We need the rowings.
Absolutely.
Because don't forget, I'm the only one that's done this and put this together. I'm sure there are mistakes in there. Together we need to find those mistakes. Together we need to correct those mistakes. We've got to make the most powerful material that anybody can use for free. Because that's how we're going to change this system. That's how we're going to create our new reality. Together. It's not just Mark doing it. Okay? All of us have something to add to help make this a better world. Okay? We've got to stop turning a blind eye. We've got to start being there for one another. We've got to start rebuilding community. We've got to know that there's others looking out for us as well. Okay? That's how we're going to rebuild trust. That's how we're going to hold people to account. Once they know they're being watched, their behavior changes. Right? Okay, anybody got any?
Well, after seeing that for the last few days, I have to say, you've got to take credit, because that is one hell of a bloody thing you put together.
Okay, if it wasn't for all of you, guess what? This is all useless.
Yes.
Okay, we're all a part of the solution. But thank you, Paul.
No, absolutely. Yeah.
Thanks for accommodating you as well.
Do you want to know about
And if anyone wants to take the
spelling
note of
mistakes?
bread home,
Yeah. On the bottom, on the comments box, spelling mistakes, missing grammar, anything. This needs to be as perfect. Okay, can I just ask people, there's a pot there, Paul's been diligently making us all coffee, he's hosted us, he's put up with us, okay? Please contribute there for Paul.
Yeah.
Right?